What happens if you get a DUI here in California, but you don't live in California? You live in another state, you have another state's driver's license, or you plan on moving to another state and getting that state's driver's license. If you're interested in the topic, or if you've recently been arrested for a DUI, stick around. I think you're gonna like this video. My name is Dodd. I've been a criminal defense attorney here in San Diego, California for the past 18 years. My firm is Dodd Law. Now, it is very common, especially here in San Diego County, for someone to get a DUI and they're an out-of-state driver, meaning they live or have a license in a different state, but now they're facing a DUI here in San Diego. And I always get asked the question, well, Dodd, I have an Oregon license. Well, Dodd, I have a Washington license. Well, Dodd, I have a Michigan license or a Florida license. Can I drive because I don't have a California license? Can I drive in that state? And the answer is not so fast. Hold on. Because once you get a DUI here in California, it doesn't matter where your driver's license is from. Your privilege to drive here in California will be suspended. So if you don't have a plan of living in California, or if you're moving out of California, what you have to do is you have to contact the DMV. You have to get a Form 1650. And what that is in California makes all their DUI drivers take a program in order to get a restricted license and to get their license reinstated. If you fill out a Form 1650, the DMV in Sacramento, and it's DMV Sacramento mandatory actions, and we'll put the number in the section below, the number that you can call to get the Form 1650 to get it filled out if you plan on driving in your home state. You fill out the 1650, then California will waive that 3-month or 9-month first conviction program requirement. And you also have to agree not to drive in California for 3 years. So how does this work? Hypothetically, you live in Texas. You're in California, you pick up a DUI, you're here over the weekend. You go back to Texas and you think you have your Texas license, so you're gonna be able to drive in Texas on your Texas license. Once Texas DMV finds out about your DUI in California, most likely they put a hold on your license in Texas. You contact the DMV here in California, you get a Form 1650, you fill it out, you send it into the DMV. We're gonna put the number below as to the number you're supposed to call. You fill it out, California will waive your requirement to do your program, and you have to agree not to drive in California for 3 years. Once they agree to that, California will lift the hold on your suspension, meaning they will lift it. So now in Texas, when you go to the DMV and you're applying to get your Texas driver's license, there will not be a hold anymore on your California license. However, most states will make you do programs or whatever they make their DUI drivers do in order to get the license. So even though California here lifted the hold and lifted your program requirement, the state that you're in might still make you do that. So that is the only way for you to drive in another state if you have a California DUI. Now, you might be lucky and you might be in the 5 states in this country that don't have DUI DMV compact with California DMV, and you can look up your state laws, but there's 5 states that don't honor it. But if you're the rest of the country, you're gonna have to fill out the Form 1650, agree not to drive here in California for 3 years. They will lift the suspension, you get it, the driver's license in your own state, and you'll be good to go. I hope that helps. I know it's very confusing. If you have any questions, go ahead and give us a call. My name is Dodd. I've been a criminal attorney here in San Diego County for 18 years. My firm is Dodd Law. If you just want to chat and talk about your case, go ahead and give us a call at the numbers below. Hit that like button, subscribe to our channel. Have a great day.